morning. Hello and happy Friday. I'm your immigration attorney, Jorge Molina, and it's a pleasure to be with you today, closing our series on inadmissibility and waivers. So today, we're going to talk about, how to get rid of an inadmissibility finding. So in the previous videos that we published and in our content, we spoke about what is inadmissibility, right? So it's pretty much a determination that someone's not allowed into the United States or allowed to adjust status in the United States. Then we talked about things that would prompt or trigger an inadmissibility finding, right? So what crimes would make you inadmissible, what immigration violations will make you inadmissible, and what other actions, right, would render you inadmissible. And today we're going to talk about waivers. So pretty much what cures that inadmissibility finding and how or who qualifies for one, how to apply for them, and what you need to show to get one. Okay, so let's start the conversation with where we left off, right? So what would render you inadmissible? Because that would control what type of waiver is eligible for you. Okay, so let's start off with, many people's favorite subject, and it's just criminal activity. Okay, so let's be clear, not all criminal activity can be waived. All right, it's only certain specific crimes and with certain minimum sentences. And by generally speaking, it's activity that, yes, it is wrong, but as a society, we can say, okay, we'll forgive it because there's so much hardship if we impose this additional burden on you and your family that we're going to let it go if you prove that you merit it and there will be significant hardship to your family. Okay, so let's look at the case of, again, forgery of a financial instrument. So pretty much, you either sign a check that was yours, or you try and present a check that was for someone else as your own, or you modify a check or another financial instrument, right? So that's what I'm looking at. So this is an offense that is categorically, meaning that in all circumstances, it is considered a crime involving moral turpitude. Why? Because there's an element of deception, right? There's something that is inherently wrong in taking that action. So by and large, all those, it doesn't matter if you're just doing it because you're trying to feed your family. It's a crime that is considered wrong, right? Morally, even if you had a good reason to commit it, it's still considered a crime involving moral turpitude, regardless of the circumstances. Okay, so let's say you did it and you did it to feed your family, or there's some other issue. And this offense is punished, generally speaking, in the state of Texas as a third degree, as a state jail felony. So meaning that it cannot fall within the petty offense exception. Okay, the petty offense exception applies to crimes that the possible potential sentence is over 365 days, and the actual sentence imposed was never more than 6 months, right? So this is not the case because the potential maximum sentence is over 1 year, right? So it doesn't fall within the petty offense exception. So what do you do, right? It's a crime involving moral turpitude. The good thing is that there is a waiver available, and that would be a waiver under Section 212H of the Immigration and Nationality Act. So that section waives several other sections. So it waives CIMTs, crimes involving moral turpitude, multiple convictions, drug possession of 30 grams of marijuana or less, and I think prostitution as well, and some other circumstances. Okay, so this is a very generous waiver. So who qualifies for this? Well, in some circumstances, if you've been fully rehabilitated, or if it would be in the national interest, you can apply for that. Or if you're an applicant for a VAWA benefit, you're also eligible for that. But most people can't really show those elements. So you're left with the catch-all category based on your relatives in the United States. And this waiver, again, is very generous, and it applies for individuals who are either the parents, children, sons or daughters, or spouses of U.S. citizens or lawful permanent residents. So if you had children under 21 and they're U.S. citizens, if you have parents or citizens or lawful residents, or if you have parents that are lawful permanent residents or citizens, or your spouse is a citizen, you would be eligible for this waiver. Okay, but not only do you need to be eligible, or quote unquote having a qualifying relative, but you need to show that not being allowed into the United States, or in certain circumstances being eligible to adjust status, would result in quote unquote extreme hardship to your relative. So there's the thing, right? So how do you show extreme hardship, and what is extreme hardship? So extreme hardship is, in essence, suffering that goes beyond the hardship expected from being separated by someone by deportation. So, for example, it is expected that if someone is removed to their home country, the family will miss them, right? So that doesn't go beyond the hardship expected from the removal. But if as a result of the separation, that person, the family member, will become depressed, anxious, really struggle with mental health, that could rise to the level of extreme hardship. And there's several other factors to consider. So, for example, financial hardship, links to the United States of the qualifying relative, ability to live in the other country, right? So perhaps the person has never left the United States, doesn't even know what life in another country is about, right? Perhaps the person doesn't speak the language, right? Or in some other circumstances, just medical history and whether you need treatment or special treatment and things of that nature. And they also assess the country conditions, right? So if it's country that is in complete disarray, there's a lot of chaos, there's no work, maybe there was a natural disaster, or just the crime levels are very high, those are factors to consider in the extreme hardship analysis, right? So that's the 212H waiver. You file that waiver in Form I-601. Okay, now Form I-601 is one of the most typical forms to file for waivers. That one and Form I-212. We'll talk about that form in a little bit. But in Form I-601, you file for criminal activity and also certain immigration violations. So, okay, so that's, we just talked about the CAMTs, talking about certain criminal activity that's waived under Section 212H. Now, for certain immigration violations, the most common one is a 3 or 10-year bar of inadmissibility. Now, I'll explain how it is triggered and who it applies to, but there's a big difference, right, in the area of law between Section 212H and Section 212A6, Roman numeral 5, in that where the one for criminal activity and multiple convictions and even possession of marijuana, you have a wide class of qualifying relatives, from parents to children. In the case of that waiver of the I-601 based on the 212A6 Roman numeral 5, only a spouse or parents that are U.S. citizens or lawful residents would qualify you. So there's a big difference there on who would be eligible for those type of waivers, which, it changes the analysis of many cases. And it could be somewhat counterintuitive, because you would think, well, immigration violations, right? These are not as serious as criminal convictions. It should be easier to get these waivers, but no, right? So often the immigration laws don't make a lot of sense. And this is one of those circumstances. But anyway, going back to that ground of inadmissibility. So what I'm talking about here is a 3/10-year bar. So how is it triggered? So if you're in the United States unlawfully, right? So either you entered without inspection, or you entered lawfully to the United States, but you overstayed, right? So you enter with a tourist visa, they gave you 6 months, you've been here for many years, right? So you overstayed. So what happens? So if you accrue more than 6 months of unlawful presence in the United States, and then you leave the United States, and okay, so you're automatically, just at the moment that you depart, not allowed to return to the United States for 3 years if you spent more than 6 months in unlawful presence but less than 1 year. Okay, so that's a 3-year bar. If you remain unlawfully in the United States for more than 1 year and then you depart the United States, you're not allowed to come back for 10 years. Okay, so in that regard, you're inadmissible under those grounds, right? 212A6. So if you're married to a United States citizen, or lawful resident, or your parents are lawful residents or U.S. citizens, you may file a waiver. In many cases, if that is the only ground of inadmissibility that applies to you, you may file a provisional waiver. So what is a provisional waiver? Pretty much it's a waiver that you can send from within the United States. So what's the typical situation? So you entered unlawfully, or someone entered unlawfully to the United States, been here many years, fall in love, they marry a United States citizen, they have children, and then, we want to fix papers, married to a U.S. citizen. How do we do this? So that is a case where we would file a provisional waiver if there's no other problems. But let's say that person, enter unlawfully, remain in the United States unlawfully, but also has a conviction, say, possession of drug paraphernalia relating to less than 30 grams of marijuana. In that circumstance, they would be eligible for the waiver for the immigration violation, and they'll also be eligible for a waiver for the possession of paraphernalia. However, you wouldn't be eligible to submit the provisional waiver from within the United States, because a condition to file the provisional waiver is that you only have that one ground of inadmissibility. So in those circumstances, unfortunately, what would happen if you want to fix papers is that you would have to go back to your home country, go to your consular interview, and then at the consular interview, they're going to give you a sheet of paper explaining that they cannot allow you to enter the United States unless you get a waiver. And then the difference here is that if you have to wait for a waiver in your home country, currently you're going to have to wait for many years, a few years at least, because of the pandemic and some other issues. But if you're only inadmissible because of the immigration violation and you're qualified for the provisional waiver, the time that you're waiting for that response, for that waiver, you're waiting from within the United States. So the determination is, well, do I want to go to my home country and wait for a few years to be able to come back, or can I just file all the paperwork from the United States, go down there for a few weeks, and then come back, right? So big difference there. But again, that's another waiver that can be filed in Form I-601. Somewhat related to a 3 and 10-year bar is a permanent bar. And here's where we're going to talk about the I-212, or the waiver filed in Form I-212. And here, think about this. So let's say you already triggered the 3 and 10-year bar, right? So you departed the United States after accruing, let's say, over 1 year of unlawful presence. But then you re-entered the United States unlawfully. And what we see often is having to explain to a person that, you know what, it doesn't matter that you did that 20 years ago, or that you went to Mexico because your mother was dying. Very sorry, but you triggered the 10-year bar. So, the permanent bar. Whereas the 3 and 10-year bar, there's a waiver available, immediately available if you have the qualifying relative. For the permanent bar, you must spend 10 years outside the United States and then apply for an additional waiver to enter the United States. And that's when you file Form I-212. Okay? So where where you would need a qualifying relative to file a waiver for the 3 or 10-year bar. For this waiver, you need to spend 10 years outside the United States, but you don't need a qualifying relative. They look at other factors. So, when you committed the infraction, the reason you committed the infraction, the need for your services in the United States, your length of residence in the United States, among other things. Okay, so with the accompanying article that we publish as well, it gives you, we explain all the factors that cover those determinations. But again, the key in those type of cases is that you must document that you've been outside the United States for over 10 years. And that is where it comes, it becomes very tricky to get the full determination and how to prove that you've been outside the United States and that your services are actually needed in the country. But, okay, so that's Form I-212. Here's important, right? So if an individual is convicted of an aggravated felony, they're permanently inadmissible to the United States, meaning there's no waiver available and you cannot come back to the U.S. Bear in mind, not everything can be waived. And here's another thing. We also spoke about misrepresentations and giving fraudulent documents to immigration authorities. So that is a ground that can be waived. However, it's similar to the waiver we just discussed, where only a spouse or parents that are lawful permanent residents or citizens would qualify you. So your children don't qualify you for that, and you must show extreme hardship to those relatives as well. Okay, folks, so, we covered a lot of information today. In essence, there's two big waivers that are the most common ones that are filed on Forms I-601 and Forms I-212. But just note that there's other wider waivers available. Before you make a determination that, okay, so it doesn't matter if I have this criminal activity, or it doesn't matter if I have these convictions in my record, I should go ahead and file because I'm eligible for a waiver. And do not file anything with immigration if you have anything that might render you inadmissible without first consulting a qualified attorney. Strategies vary in how to present cases and the information you want to provide. And just remember that all these cases can be denied on discretionary factors alone. Immigration can say no, even if you qualify, we're not going to approve it. So, a good lawyer would prevent a situation where they deny it on just mere discretion or because there's just a bad record. Okay, but folks, I really appreciate the questions that we've received beforehand. I think I've addressed most of the questions presented to us. Again, this is the last installment on our pieces on inadmissibility and waivers. Okay, so again, my name is Jorge Molina. It's a pleasure being with you and sharing this information with you. You can always reach us at 469-708-5800. Again, 469-708-5800. Or you can send us an email at info@jmolinalawfirm.com. Again, Jorge Molina, thank you for watching.